Let's get started, shall we? Let's first tell you about what happened today around the issues of the governorship election in Ekiti State, as the petition tribunal has upheld the election of Kayode Fayemi as the duly elected governor of the state. The three-man panel of justices in a unanimous judgment that lasted almost 5 hours earlier today dismissed the petition filed by the People's Democratic Party (PDP) and its candidate Professor Olushola Kolapo Olubomi for lacking in merit and in substance. The tribunal held that the various allegations raised against the election conducted by the Independent National Electoral Commission on July 14, 2018 were not proved as required by law. Let's get started, shall we, everyone, on our main story of the day, which has gotten us talking for the past days. Last week's suspension of the Chief Justice of Nigeria, Onnoghen, has generated so many ripples. Today, lawyers and members of the Nigerian Bar Association took to the streets of Abuja as part of efforts to register their displeasure over the suspension of the Chief Justice of Nigeria. The Nigerian Bar Association has directed its members to embark on a two-day nationwide boycott of all courts in the country. Rising from an emergency National Executive Committee meeting of the association, the president of the association, Mr. Paul Usoro, says the two-day warning boycott of all courts in the country will take effect from Tuesday, the 29th of January 2019 to Wednesday, the 30th, with a possibility of an extension. Meanwhile, a counter-protest have also been staged in some parts of the country. The supporters of the president's decision have applauded the move to suspend the head of the judiciary. And at the lawmaking arm of government, that is the National Assembly, there is a change of mind from the planned sitting of the senators tomorrow. Earlier today, the Senate filed a case at the highest court of the land. Of breaking news that we are giving to you right here on Channels Television. They've gone to the Supreme Court seeking its interpretation on whether President Muhammadu Buhari acted within the provision of the Constitution in his suspension of the Chief Justice of Nigeria, Onnoghen, or whether the action of the president does amount to usurpation of the powers of the Senate as provided for in Section 292 of the Constitution of the land. Following the filing of the case, the matter of the suspension of the CJN, according to the Senate, which is the main issue for which the Senate had planned to reconvene tomorrow, has become sub judice, and their planned reconvening has now been put off. Let's get started on this matter and get some legal opinion and perspective to this one. I'm now being joined on the program by rights activist and a constitutional lawyer, senior advocate of Nigeria, Chief Mike Ozekhome. Thank you so much for coming on the program tonight.
Thank you, Sheon Kimbaloye.
You're welcome.
Thank you, Nigerians. You're welcome.
Let's start. Does the president have the power to suspend the CJN?
No. No. No.
On the premise by which he did, on the ex parte order from the CCT.
He does not have the power, whether on an ex parte order or on a motion on notice or even on a court judgment, because the powers of appointment and suspension of the Chief Justice of Nigeria are matters that are governed by the clear provisions of the Constitution. Sections 153, Section 158, Section 291, Section 292, subsection 2, and the third schedule, Section 21, Pass 1 and 2 of the 1999 Constitution. What do they say? By way of summary, they say it is the NJC that nominates a person for appointment to the CJN. Then the Senate, by 2/3 majority vote, confirms that appointment. The president merely plays a nominal role of now swearing in that person. It is the same route you follow when you are dismissing. The NJC recommends. The Senate, by 2/3 majority, approves. Then the president can remove.
So it doesn't have the power to fire.
No.
It doesn't have the power to hire.
No, he does not have the power because of people.
Well, this negates your position when the issue of the governor of the state at the time. Yes. You did say you supported the move that the president had a power to hire and fire.
Yes, I saw that flying in the social media, and yesterday I replied. I laughed and I guffawed at the misinterpretation. I made that comment in 2014, and I stand by it, because the governor of Central Bank is appointed by the president. He can decide tomorrow and say, you, Sheun Okunbaloye, you are the one I'm appointing as governor of Central Bank. So he has the right to hire. Then he also has... In the case
of the CJN...
I'm coming. He also has the right to fire. So what I was interpreting is that there was a lacuna. The CBN Act, Section 5, having given the president the power to hire and fire, did not state whether the president can also suspend. It is when you have a lacuna, you call in aid Section 11 of the Interpretation Act, which I called in aid. Contrary to that, the CBN, the NJC matter, the Chief Justice matter, is a different kettle of fish. It is one of the only areas the three arms of government are involved. The CJN, the Chief Judges of the High Court and the Federal High Court, the Grand Cadi of the Court of Appeal, and the President of the customary Court of Appeal. All of them are covered with that near immunity that the president, for example, the president cannot sit down and say, I'm appointing a person as president, as a Chief Justice of Nigeria. No, but he waits for nominations and confirmation.
Senior advocate,
that's the difference.
Does the law also spell or foresee a suspension? Because the president has not removed the CJN. Yes, he has merely suspended, asked him to step aside.
The law does not envisage a suspension.
So can we now say the president is wrong in suspending him?
It's wrong. The only body that has the power to suspend is the NJC. And since the Chief Justice is involved, all they need to do is to convene, and the Chief Justice will not sit to chair it. It has happened before in the past.
But again,
when Katsina Alu was there and the matter concerning him, he did not sit.
Senior advocate,
so also, he will not chair it.
So also, you remember that in the recent cases of the judges, when the houses were raided, under the CJN, Water Onnoghen, it was also ratified, from what I gathered, the report I have, that any judge or any judicial officer that is under investigation will step aside pending the determination of the case.
That is a matter of morality. Morality and law are not contaminated. They are not the same.
So it cannot be reflected on the case of the CJN?
You cannot. The CJN occupies a special place like the chief judges that I've referred to and the Grand Cadi. It's not just like any judicial officer. It says for you to remove him or even any other judicial officer, the NJC must meet. That was why in the case of Ereru Habib
of Kwara
State, the former chief judge, when the then governor removed her, she went to court and the matter went up to the Supreme Court. And the Supreme Court said, hello, you cannot, as a governor, remove the chief judge of a state. The same case came up in Ngajiwa's case. And the Court of Appeal said, for you to remove any judicial officer, not to talk of the Chief Justice of Nigeria, you must first go to the NJC. That is what the law says. Those are the sections are quoted. So there is no portion of our laws that allow a court of law to grant an order removing the Chief Justice, not to talk of an ex parte order.
What about the judgment of the Supreme Court, which held also Justice Water Onnoghen was also part of that. That says the highest body to sit on the issue of the conduct of a public officer is this the CCT.
Nobody is doubting that. Nobody is challenging the powers of the CCT to look into a matter.
Because you know the process started from when the petition was taken to the CCT.
The petition has to do with breach of the code of conduct. Those are the only matters that the CCT can and CCB can have jurisdiction over. Breach of the code of conduct. Don't forget that a petition came from one Aganye, who was former PA to Mr. President between 2009 and 2011.
Was he a PA or
no, PA. Then he became PRO, spokesperson to CPC, party formed by the president. Then he became one of the founders of TBO, the Buhari organization, which campaigned for him. Now, look at the queer situation. On the 7th, he wrote a petition right? Talking about personal details of an account concerning the Chief Justice of Nigeria, which he ought not to have access to because only the bank, in accordance with the rule of Uberima Fidei, utmost good faith, has access to. And then the security agencies, mean that the security agents must have given him the BVN. Now, he writes the petition on the 7th. On the night, 2 days later, with automatic alacrity, permit that military word of those days, phrase, the CCB received the petition. By 11th, they had already prepared charges against the Chief Justice of Nigeria, and they filed the case for 14th, all within 1 week. Now,
that was too fast.
Now, the president...
Was that too fast?
Not just too fast, it was bizarre because of the political coloration of it. The same president who is now saying he was quickly acting on an ex parte order granted by a court that had already adjourned proceedings to today to hear the issue of jurisdiction. And in law, let Nigerians hear this. When you challenge a court's jurisdiction, the only jurisdiction it has from that time is jurisdiction to determine whether or not it has jurisdiction.
All right.
It cannot make further orders. Now, the president suddenly said he was acting on that ex parte order. Mind you, the ex parte order was said to have been filed on the night, 2 days before the charges were even filed on the 11th.
All right.
Apart from that, the president, who has not been known to obey court orders, 6 court orders that Colonel Sabo Dasuki be released on bail, including an order by ECOWAS court, the sub-regional court. Right. He refused them, including that of Ozekhome.
Time flies so fast.
Yes.
Just in 30 seconds.
Yes.
The CJN came out to say, I made a mistake.
Yes.
Round up by telling us the implication of that and what the NBA has said today. In 30 seconds, we're out of time.
Yeah, the implication of that is that the normal law is what you call ignorantia juris non excusat. Ignorance of the law is no excuse. But ironically, for these people, it's not the CJN that made the law. Section 3, subsection D of the Code of Conduct Bureau and Code of Conduct Act says where a person confronted with non-declaration or partial declaration of assets admits non-compliance, the CCB shall not refer the matter to the CCT for trial. It ends here. What do? They give you other forms. They say, take.
All right.
We want you to refill this form because we noticed that you did not put up. The reason is simple. The CCB and CCT Act was not meant to be an ambush on public officers. It was meant to make them to comply. That is their job.
Senior Advocate, we're out of time. I'm so sad that we cannot continue, but we have to take a break.
So everything we are saying is that
we need to
the president, the executive, they got it wrong. This is what we call mob lynching action. They are just trying to lynch the Chief Justice for political reasons, and it's not acceptable to Nigerian lawyers. That is why today the NEC met and said, let us start a warning by boycotting courts from tomorrow for 2 days in the first instance.
Senior Advocate, constitutional lawyer, rights activist, Chief Michael Ozekhome. It's a pleasure having you.
Yes.
I wish we had more time to talk about
it.
Yes,
Sheon, give me more time next time.
Next time.
Yes.